I don't know what that means, sir. Are you not a person?
I am a living man.
What does that mean?
I am a man.
You are a man, I'm a woman, but I'm here. You're here? I'm
here as a living man representing myself.
Okay, sir, this is not I'm finding it's not a due process violation. You are here. People are allowed to make appearances before the court. You've made an appearance before the court multiple times now. I'm not dismissing this lawsuit.
It's a man as I hear of the Dean family, and I'm here on special appearance. Yeah, so I actually have the definition from Black's Law Dictionary, and I've got an objection to that, Your Honor. As long as civil procedure is not followed at the very beginning.
I am denying the special appearance.
I'm just objecting. Objection. I've got an objection. I do have an objection for the rest of the proceeding.
Confirm support arrearage. This was filed by the Attorney General's Office November 27th of 2024. This is a remote proceeding, and I find nobody has objected to proceeding this way.
Objection, Judge.
Okay, one moment, sir. Ms. Baskins, can you please state your full name for the record?
Yes, ma'am. It's Adrienne Baskins.
Okay. And, sir, can you state your full name for the record, please?
Yeah, I'm Zahir Dean, the living man.
Okay. And Mr. Dean and Ms. Baskins, can you both please raise your right hands to be sworn in? Again, a few housekeeping items. The first is I am an associate judge, and you do have the right to a de novo hearing before the referring court regarding decisions I make. That being said, Mr. Dean, you wanted to say something?
Yes, thank you, Judge. Judge, I'd like to say I'm here on special appearance. But first, we were here last time, and I was really sick and I wasn't able to speak. So I appreciate you giving me the time to recover and come back here today.
Better.
So I'm here on special appearance, Judge, and I am looking for a dismissal of this case due to due process violations. I was not given proper notice, and in the notice, I wasn't given clear statement of the proposed actions. I wasn't given the specific reasons or grounds for the proposed actions, including a description of the facts and evidence upon which the actions based off of today. I wasn't given sufficient detail so I can understand what is at stake and what I need to contest or respond to. I wasn't given information about how to access the procedures for responding or contesting the actions, including contact details. So because of this, I'm requesting a dismissal of the case, Your Honor.
And just for clarification, sir, have you filed anything requesting this relief?
No, because I don't know what's going on.
Okay.
I don't have any information. Was not noticed properly, given the proper notice. And because of that, there's no way for me to proceed.
Yeah, I offered to email them to him this morning. He was served back on June 10th by side posting, and so on his door, he was served.
Objection. Is there evidence to prove that, Your Honor?
So I'm looking for the service return right now.
It says on June 10th, 2025, it was posting the citation to the front main entry door per Texas Rule 106.
And I do take judicial notice of that executed service return.
So that was just a preset, but this is also the motion to confirm and the motion for substituted service was all served on him.
Oh yeah, it's multiple. Yeah, the 3 pages in that service return.
If I got an objection on that, Your Honor, it says it's posted on my front door.
At the front main entry door is what it says.
Yeah.
Yes.
I did not receive that, Your Honor.
Okay.
I've got an objection to that.
I believe he also signed the reset last time we were here.
Yes, I do believe you've made an appearance in the case. So, sir, you're claiming right now that you don't have a copy of the pleading. Is that true?
I've got an objection to that as well, Judge. So when we were here before, I did have a means to communicate with the clerk prior. However, during the Zoom when we were speaking to you, I did not have a means to communicate in terms of chat for me to object to that. But now I'm able to speak. I agree on a reset to come back to figure out what's going on here. But my objection still is for due process not having a sufficient amount of information.
And I'm willing to take a short reset. I can email him the pleadings. I've offered to do that before, and if he needs a chance to look them over.
Yeah, and I've got an objection to that, Your Honor. Due to the due process violation, I'm requesting a dismissal.
Okay, sir, this is not a I'm finding it's not a due process violation. You are here, people are allowed to make appearances before the court. You've made an appearance before the court multiple times now. I'm not dismissing this lawsuit. It's a matter of making sure you do have proper notice to proceed, though, and fairness. And so I do want you to receive a copy of the pleading so we can proceed. I do believe last time, Ms. Khan, because I thought this case involved a modification and confirmation. I believe last time Ms. Khan, correct me if I'm wrong, I think it was this case, corrected me and said this was just a confirmation of arrears. We're just confirming arrears in this case. Could be all sorts of things. And I want you to have your day in court in fairness. But I am denying the request to dismiss this action. I don't find this been a due process violation. Have you provided Ms. Khan information, a way to send you a copy of the pleading so you can review it?
Your Honor, so I've got an objection on the appearance as well. I'm not here, or have ever been here on general appearance. I've always represented myself under special appearance.
I don't know what that means, sir. Are you not a person?
I am a living man.
What does that mean?
I am a man.
You are a man. I'm a woman, but I'm here. You're here.
I'm here as a living man representing myself.
Under what legal basis are you doing that?
Under constitutional law.
I'm finding you're here and you're making an appearance, sir. I don't know what law you're referring to. If you'd like to cite a specific statute or a specific part of the Constitution, I am open to reading it. But my understanding of the law is you're here, and there's no legal representation of yourself in that form. So I would like you to receive a copy of the pleading. I'd like you to review it. If you need additional time, I'm even open to resetting this to the December 11th date, although I'd rather not. But in fairness to you, if that needs to happen, I will give you a little more time.
That would need to happen, Your Honor.
Okay, but I want you to receive a copy of this pleading so we don't have the same discussion next time.
I don't know if you heard me, but I'm sorry. I said I received it.
Okay, thank you. So you did receive it?
I did.
Confirm.
I did via email.
Okay, do you want to review it now, or do you want some time to review it before we proceed?
It's a pretty long document. Yes, very long document. I'll definitely need time to review.
Okay, and just so you know, despite the length of the document, we will be proceeding to final trial on December 11th, 2025. No more resets. Mr. Dean, can you state your full name for the record, please?
Yeah, I'm the man as I hear of the Dean family, and at this moment, I would like to say that I'm here on special appearance, and I don't consent to any agreements, or I don't give up any of my rights.
Well, right now I'm just swearing you in, and we'll get to your special appearance in a moment. I understand you want a hearing and don't agree to anything. Ms. Baskins, can you state your full name for the record, please?
Yes, it's Adrienne Baskins.
Can you both please raise your right hands to be sworn in? Mr. Dean, is your hand up?
Oh, yeah, sorry.
Okay, thank you. Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can both lower your hands. And counsel for the Attorney General's office?
Julie Kahn for the Office of the Attorney General.
Okay. Mr. Dean, did you file anything about a special appearance?
I did.
You did?
I did.
Okay. Would you know about when you filed it?
I filed it yesterday, Judge.
It has not made it to the court file. Is Ms. Foote, do you see it? Is it in the documents?
No, ma'am, I don't, but I will check e-file and see if it's in there in advance.
Did you electronically file it, sir, or did you walk it?
I did. I e-filed it, and I've got an, I can get you the envelope number.
You have emailed it to us. Is it the affidavit of truth?
Yes, I emailed it to you as well. In addition, I e-filed. I've got an envelope number if that would help. Would the clerk like the envelope number or?
I don't need it. I can check by the case number. I'm checking right now. There is a demand letter as the description. It has not been accepted. I'll get it accepted right now.
Thank you.
And Judge,
It's been accepted. It should come up in the system in just a few minutes.
and Judge, you mentioned you're coming outside of Montgomery County. Specifically, where are you coming out of?
I am in Harris County, and I'm doing this pursuant to the Family Code 201.1045. My clerk is in Montgomery County today.
Judge, it is in the file now.
Showing, let me click on it.
Judge, you might need to go out of the case, then come back
I
in.
found it in the documents tab, so I think
Okay.
I can pull it up that way.
Okay, thank you.
I'm going to take a moment to read this. Mr. Dean, why don't you proceed on your pleading? Although I'm going to say I don't believe this is timely, but you can explain to me why it is.
Okay. So Judge, so all of the times that I've came into court, I've always mentioned that I'm under special appearance, and the sole topic.
Means to you?
Yeah, well, I actually had the definition from Black's Law Dictionary instead of giving you my interpretation of it. All right. So under Black's Law Dictionary, it says special appearance is when a defendant appears in court solely to contest the court's power over them without submitting to it, often called limited appearance. General appearance is basically when someone comes into court accepting the jurisdiction and so forth.
Okay, so can you explain why the court does not have jurisdiction over you?
Yeah, so because civil procedure was not followed under Rule 107, that identifies that the court doesn't have jurisdiction to proceed with a judgment because the civil procedures was violated.
Would you like to flesh that out more, sir, or do you want to leave it at that?
And you mean in terms of
What you're saying?
so basically
How was
what
it
I'm saying-
violated?
Yeah. So there's not a return to service that was filed, and specifically in the affidavit, I've listed out the Rule 107 for return of service. That's the requirements for it, and that was not followed. Because that was not.
Can you specify what part of the return of service was not followed?
Yes.
There is a return of service on file. So which of those many rules you listed out did not happen? Or should we go through them one by one?
So there's not a return to service on file, Your Honor.
There is an executed citation, a constable return of service and citation. It was filed with the court, I believe, June 16th of 2025.
Was that under e-file?
It's in the court file. I'm not sure how it got here.
Is Mr. Dean done? Is it?
Yeah, Mr. Dean, are you looking at something, or is there more you'd like
No,
to say?
I'm sorry, Judge.
Okay,
I'm sorry,
I thought you were looking at something. I wanted to give you time to look for what you needed to prepare.
Oh, okay. I'm sorry. I thought I was waiting on you. I thought you were doing something to where.
Then I was just waiting to see.
Okay. So the document you're looking at, Judge, you're saying it's on the court files?
In the court file, yes.
In the court file. So I'm not seeing that under e-file. And when I looked up that information, there
Are
was.
you in research? What system are you using to look up information? Because it's possible it's just not there because it's not the official court file.
Okay.
But I don't know what you're looking at. Ms. Khan, are you able to see it in your accesses?
I can share the screen, Judge, if you would like to show where he was served. I think we did this last time too, though, at the last hearing. And we acknowledged that it was service by posting on the door. He said he didn't get a copy of it. And so I emailed
That's him.
and he acknowledged on the record that he had received it. And so we've already.
Yes, Judge, and I had an objection to that, still identifying that's not return of service under civil procedure.
Is there anything else you'd like to say, Mr. Dean?
Ms. Khan was saying that she was going to share that document with us.
I mean, I feel like we've already covered all of this, but.
We haven't. The last time we were here, we did not see that document.
You may pull it up, Ms. Khan, so you can see it.
This is the second page. First page is just the citation, and then this is where he stated where he left it.
So I was speaking to Ms. George, and she is stating that this is part of the citation. It's not the return to service.
I'm sorry, who's Miss George?
She is the child support case representative, Tanisha George. So this document is the actual citation, Your Honor.
According to the child support officer.
Yes, ma'am.
Ms. Cott, is there anything you'd like to say in response to his allegations?
Judge, he was served by substituted service, and it is newly on file. There was proper motion filed, so following the rules of civil procedure. And also his issues with saying that he had not received a copy of it. He has since received a copy of it, accepted that copy. So at this time, I would think that we should be able to move forward.
And I've got an objection to that, Your Honor. As long as civil procedure is not followed at the very beginning, there's no reason for a judgment because the civil procedures was not followed initially, according to Rule 107.
And Ms. Baskins, is there anything you'd like to say?
My understanding is we're just confirming arrearages today. I'm not sure what the trouble is.
Can you please stop sharing?
Yes, Judge.
Okay.
Oh, I'm sorry. Oh, yeah, I'm sorry. That's fine. All right.
Just so I can see everyone. Was there something else you wanted to say, Mr. Dean?
I'll say anything else if anyone else has anything to say for me to rebuttal, but if no one else has anything to say, I'm fine. I'm good. And Ms. Baker,
Judge Baker. Yes.
Oh, Judge Baker, I'm sorry. Apologies. Judge Baker, on this recording here, is it public record? And where can I go to get a copy of the recording?
You would have to request that we send it to you, sir.
Okay, thank
You
you.
don't post it online or in a file for the world to see. It's not public record.
Okay,
And
that's
probably audio recording, we don't have anyone to transcribe or officially do any of that.
okay. That's good to know. The last time we were on here, someone recorded and posted it online.
Okay. And people, we broadcast on YouTube, sir, and people do that. They are not supposed to. As you can see, there's a little screen up that says recording is prohibited. If you know who did it, please do let the court know.
Okay, thank you.
But right now it is on YouTube, but I take all my YouTubes down almost immediately following the hearings.
Okay,
They are not posted for perpetuity online. But if you do know who did it, please let us know. And nobody here should be doing that. Ms. Baskins, you should not be doing it. Mr. Dean, you should not be doing it. No one from the Attorney General's office or the clerk's office should be doing it. And nobody who is watching right now should be doing this.
okay. I definitely did get some hate
I'm sorry about that.
harassment items with it.
Yeah, and I don't like it being up there either because the same applies to all of us up here. We all get that, including me. So, but we do have open courts in Texas, and if we were live in the courtroom, anyone could come and watch it as well. So this is how the people who make the decisions have deemed we comply with that provision. Okay, I am denying the special appearance. I'm finding the return of service is on file with the court and on its face valid. Also finding a motion to quash could have been filed if there was a claim of defective service. And under Rule 122 of the Rules of Civil Procedure, if it was quashed, you would be deemed served by 10 a.m. the Monday next after the expiration of 20 days. It's a regular answer time. And it would have, at that point, you'd be in the lawsuit. So I'm not finding that there's anything that's been pled or argued that would show that the court does not have.
He believes repeating special appearance protects him from the court's authority. But the judge is explaining something critical. Even if service had issues, the proper move was a motion to quash, filed early in writing. By skipping that step, he loses the timing advantage. What feels like standing on principle is actually surrendering leverage. The court isn't debating philosophy anymore, it's tracking procedure. And procedurally, he's already inside the system he's trying to reject.
Jurisdiction over you, sir. There's a prior order in this case. So I do find jurisdiction is proper and the return of service on its face is valid. You may proceed, Ms. Khan, with the motion to confirm arrears.
Yes, Your Honor, I would offer the pay records. We have two in this case. There's one from the Harris County cause number and then one from the Montgomery County cause number. I may share the screen.
You may.
Mr. Dean has been sent copies of these today via email.
Okay, wait, before we share screen, does anyone have an objection? I'm confused as to, since the case was transferred here, I'm confused as to why there's two pay records. But Mr. Dean, what is your legal objection?
I have an objection. I was here under special appearance and I'm prepared to be here under special appearance. Now that the court is transitioning this to a general appearance, I request time to prepare.
So you were given time last time to prepare?
Under special appearance, Your Honor, and I did.
But that has been denied. This case was filed November 27th. We're already after over a year.
Correct. So you've denied it today under special appearance. Now that you've denied it under special appearance and it's a new appearance under general appearance, I'm requesting time to prepare under general appearance.
Ms. Khan, do you have a response to that?
Judge, this case is already over a year old. I have a feeling that it will be dismissed if we don't go forward today.
I've got an objection on Ms. Khan's feelings of being dismissed as not evidence.
Ms. Baskins, is there anything you'd like to say?
Right. I mean, this is like our fourth or fifth time to reset this. I feel like the matter at hand, simply confirming arrearages, is we're not arguing about anything else. I feel like it's pretty straightforward.
I'm going to deny your request, sir, and we're going to proceed today. We're going to begin, and just a few housekeeping items. I am an associate judge. You do have the right to a de novo hearing before the referring court regarding decisions I make. As I said earlier, nobody should be recording this. There should be no audio recording, video recording, or broadcasting. Everyone should be speaking in civil tones, which you are doing, so thank you for that. And we generally take testimony, so one of you will be asked questions at a time by the AG. Since you're both representing yourselves, you'll both be given a chance to speak as well at the end. And then just be aware, aside from things that have been said before me, I don't know what you all discussed in the back or on calls with the AG's office, so just be aware I'm not with them. So you might be asked questions or things that you've discussed previously. Just be aware that that's how I do get the information. And so does anyone have any legal objection?
I've got an objection, Your Honor.
Okay, what is your objection? Can I finish what I'm asking that what you're objecting to?
Yes.
My question was, does anyone have any legal objection to the pay record or the pay records that Ms. Khan is attempting to admit?
I've got an objection to it, Your Honor.
What is your legal objection?
So Ms. Khan is a third party in this case. The case is between the state of Texas and myself, and I'm wanting to know, Ms. Khan is a third party submitting evidence. Is the state of Texas submitting any evidence as well?
I'm sorry, is the state of Texas doing what?
Submitting evidence. It's two separate entities, Your Honor. Ms. Khan is with the Attorney General Office, and according to the communications that they've been sending, they are a third party. And the case here today is between myself and the state of Texas. I'm wanting to know, is the state of Texas providing any evidence, or is Ms. Khan providing the evidence?
I don't think you understand. Ms. Khan represents the state of Texas. The Attorney General's office is part of the state of Texas. And I'm overruling your legal objection. Do you have any legal objection to the documents?
So, no, but I do have another objection, Your Honor.
Okay, what is your objection?
So the second objection is that if we're going to move further with the case, I'm requesting a trial by jury.
Okay, that has not been timely requested, nor are you guaranteed one in this case. So I'm denying that request.
I've got an objection to that, Your Honor. Since as of today, we're moving forward with general appearance, I'm requesting a trial by jury because this is a new appearance, and I'd like to get time to prepare for a trial by jury.
Ms. Khan, do you have any response to that?
Judge, in Texas, a jury doesn't determine issues related to child support.
Yeah. What is the jury issue? I'm not sure a jury would hear a confirmation of arrears.
Sir, I'm just objecting to exercise my right to trial by jury.
I would argue that child support is a legal issue and reserved for the court and would not be an issue for the jury.
I don't object to that, Your Honor. Is there evidence to that statement? Is there a rule, a law to that statement? Or is it just Ms. Khan's opinion?
It's Judge's Family Code Section 105.002 lists the issues that may or may not be sent to a jury. And it does say 105.002C2 states that the court may not submit to the jury questions on the issue of support under Chapter 154, child support, and several other things, but that's the one.
Thank you. And I'm finding this request not timely. Based on 105.002, this is not a jury issue, and it is not a timely jury request. Jury requests must be made in writing. This is not in writing either.
Muted.
And so, does anyone have any legal objection to the pay records being admitted into evidence?
Your Honor, I know that you're going to proceed from now on, but for the record, I'd like to state I do have an objection for the rest of the proceedings.
Overruling your objection. Ms. Baskins, do you have any objection to the pay records being admitted?
I do not, Your Honor.
Okay. I'm admitting the pay records into evidence of States Exhibit 1 and 2.
Judge, if I may share the screen, I'm sorry, I lost it now. Did it share? It didn't do it.
It is shared.
Okay. Is this the
Like the Harris County?
2021? Yeah. So Judge, this one shows as of November 30th, child support arrears of $12,353.91. Stop.
Can I look at that closer? So what is are you going to ask questions about this so I get more information?
I can a little, yes, Judge, but I was just going to show the numbers first. So this is as of November 30th under the Harris County cause number, there's 12,353.91. And then under the Montgomery County pay record, there's child support, medical support, and dental support. As of November 30th, child support is $2,610.62.
Sorry.
Medical
Child support was for what?
$2,610.62. The medical is $1,601.81. And then dental is $159.98. Okay. And at this time, I would call Mr. Dean. Mr. Dean, can you state your name under?
Yes, I am the man Zahir Dean.
And do you understand that y'all had a divorce decree in Harris County? Is that correct?
Yes.
And then it was transferred to Montgomery County, and y'all got a new order and a suit affecting the parent-child relationship that changed the amount of child support. Is that correct?
Yes.
And for whatever reason, that order didn't combine the arrears from that prior order from county. And so today we're looking to combine both of those together into one number. So it'd be, so instead of 2,610.62 and 12,353.91, we combine it under one cause number so you don't have two different cases to pay into, and it would be 14,964.53. Are you in agreement with that?
I don't know what you're like. I don't know the details of what you just said.
Okay. So do you understand that y'all had two different cases? Y'all had a case in Harris County, the divorce decree, correct?
Right.
And then you came to Montgomery County, you transferred the case, and then you had a new case that changed the child support amount a little bit for the Montgomery County case, correct?
Right.
And you've seen the pay records I've sent to you, and I've shared them on the screen. Do you have any dispute that the pay records are correct?
In terms of what I've been paid at work?
In terms of what payments have been made towards this case?
And the information that you've shared with us earlier on the pay records, did you pull that directly from the child support account under the Attorney General? Okay. Yeah, that's a tool that they've used to garnish wages.
Okay, so are the pay records correct so far as you know?
I haven't reviewed it, so if that's the tool that they're using for the pay records, then that's the tool that they're using for the pay records.
Have you made any direct payments to mom, giving her cash instead of paying through the OHUs?
No, I'm court ordered not to. I'm court ordered to directly pay through the Attorney General's tool.
Okay.
Any payment towards mom directly would not be considered a payment.
Okay. So do you have any reason to dispute the numbers that we're saying that should be combined together into one judgment?
I do have an objection based off of me being here today based off of the initial rulings from my objection.
But you don't have anything to say about the numbers?
No.
I'll pass the witness.
You may call your next witness.
I'll call Ms. Baskins. Ms. Baskins, I think you're on mute. Can you state your name?
Adrienne Baskins.
So today I'm just trying to combine the arrears. I want to confirm the child support arrears as of November 30th for $14,964.53, medical support arrears for $1,601.81, and the dental support arrears for $159.98. Are you in agreement with all of that?
Yes, ma'am.
All right, I pass the witness, Your Honor.
The state does not represent either of you, so I'm going to give you both a chance. If there's anything additional you'd like to say that you think I need to hear about the arrears and what the state is requesting. Ms. Khan, why don't you do a quick summary, because I think you have one already of what you're asking for, and that way everyone will know exactly what you are asking for if they want to object to it or contest it.
Yes, Judge, we're just asking confirm arrears as of November 30th, 2025. Child support arrears would be the amount of $14,964.53. The state would ask for a payout of $100 a month. Medical support arrears of $1,601.81.
Slow down a little so everyone can follow that. Medical is
$1,601.81, and the state is asking for a payback of $20 a month. And then the dental support arrears of $159.98, and we're asking for a payback of $10 a month towards that.
okay. So,
Your Honor.
Would you like to respond to that request?
Yes, Judge. I've got an objection. I saw the Attorney General's data for the actual child support, but I did not see the supporting evidence for the medical, dental, and so forth at this time on how that number came about.
Ms. Khan, would you like to call the witnesses on that issue?
I can just answer the question. It's based off of the 2024 order that the parties had entered into. I think that
I don't know if I can take judicial notice of that order, including page 20 of 29. Orders Zahir Dean to pay Adrienne Danielle Baskins as child support the amount of $318.80 per month for the cost of health insurance, with that first installment being due and payable on August 1st, 2024, and a like installment being due and payable on or before the first day of each month thereafter. So that's where the cash medical comes from. And the dental support starts on page 21. And there's a paragraph on page 22 that says Zahir Dean is ordered to pay Adrienne Danielle Baskins as child support the amount of $30.95 per month for the cost of dental insurance. And then it continues with that same, if that helps. I'll take judicial notice of that 2024 order. And you may continue, Ms. Khan. Since I had it up, I figured I would help you there.
that would, and then it's also reflected on the same pay record that we had already discussed.
So I've got a clarification that needs to be made, Your Honor.
Okay.
So when they say that I needed to pay that, right, is it under the impression that it's going to be pulled under a garnishment of my paycheck, or?
I'm going to stop for a moment and say I am not on the witness stand, but I'll give you just some general information. When child support is due, it is due. I believe there's even a section in here that says who's all due and owing. I usually, if I'm setting child support, have been known to give a speech something like this. You are responsible for making your child support payments. Generally, the AG's office will issue a wage withholding order. If you don't have the AG's office in your case, usually a private lawyer will issue a wage withholding order. But you are ultimately responsible for the payments, not that wage withholding order. And so what I always encourage people to do is to look at their paychecks, look at what is due, make sure the full amount, especially when modifications happen. Often things don't happen quick enough. I don't know why. It's not always the AG's office's fault. Sometimes it's the employer, but for whatever reason, it doesn't always quickly happen. And so people need to look at paycheck stubs and look at what's coming out and look at what's due and pay anything extra that's not due. Not everyone works for a company where you can withhold. Some people have jobs that they have to make they have to make payments themselves through the SDU, where that wage withholding order is not effective and they are not relieved of their child support payments. So I'm not sure if that answers your question or not, sir, but ultimately, however the payments get made, they're supposed to go through the state disbursement unit and you're supposed to pay them.
And it looks like we had someone join in, Wendy Cordova. Oh, she just jumped back on.
We're open courts, so people are here for all sorts of things, but they are all participants or with the AG's office. Ms. Baskins, is there anything else additional you think I need to hear?
Not at this time, Judge.
And Ms. Khan, just to clarify, because that was up pretty fast, the amounts that were due under the Harris County order, they stopped once August 1st came around of 2024, I believe it is.
Yes. So
There's no double dipping.
I think it looks like it even, yes. Last one was April 30th, 2025. Well, oh no, I see it. July 1st, 2024 was the last time we billed for that one. And then I believe.
And then this starts up on August 1st of 2024 for the Montgomery.
Yeah.
Okay, so they.
Yes, the last time we billed him was July 1st, and then it switched to the other one.
Okay, I'm going to confirm the child support arrears based on, actually, what I'm going to do, Ms. Khan, I'm concerned about interest, and I'm not sure what will happen, so I'm going to confirm the arrears in the Harris County cause as of July 31st of 2024.
Okay.
Here in Montgomery, though, so that you can enter into your system the judgment as of that date, and then the Montgomery numbers will just roll from there. Because I don't want to.
It's actually higher, which is weird.
Because some payments were made since then, or?
Yes, there were payments made since then.
That's so okay. So those payments will still accrue, and it'll all go down. Correct?
Yeah.
Okay. And so as of, did you understand? So what I'm going to do, sir, I don't want to possibly double dip on interest. I don't think it's a doubling, but I do think mathematically this will be less interest in the long run. I could be wrong. But I think I don't want to compound anything. And so I'm just going to confirm the arrears that were due based solely on the Harris County order that is now transferred to Montgomery and is here in Montgomery as of July 31st of 2024. So that will be the starting of the pay record for Montgomery now is whatever was due under the old order. And then anything new that accumulates or gets applied will get applied all combined now in that order. So anything you've paid to either causes since then should continue to apply, correct, Ms. Khan?
Yes.
Okay.
So
what is the number as of July 31st, 2024 for?
12679.31.
Okay. I'm going to confirm the child support judgment as of July 31st, 2024. There was no Montgomery County obligation at that date, so there's no confusion there. So the judgment against Mr. Dean in the amount of $12,679.31 as of July 31st, 2024. I'm ordering that he pay that back at a rate of $100 per month, beginning January 1st, 2025. Step ups as child support goes down. So the child support's going, let me get those numbers.
Go up to $19.94. What is it? Child support.
Those two children. There's a step down.
Oh, yeah, there is.
So the first one is $18,949.
It's 17.
So it looks like $478.67 will be the first step up. The next one would be $1,993.34 until paid in full. Does that make sense for drafting?
I think so.
Okay. And so the state's going to draft the order based on my ruling today, and they'll be circulating it to y'all through DocuSign to review and sign off on. And then you'll be free to go. But thank you all for coming in, and good luck with everything going forward.
Hey, Judge, what I'd like to do is once she sends it through DocuSign, I'd like to print it out and actually sign it in my own handwriting.
Should we set this for entry?
We can. And do you want to bring it in person?
Oh, I guess I can just email it back to you.
You have that capability to print and email back today?
I do.
Okay. I guess we don't need an entry date then?
I mean, if he doesn't sign it by today, I'm probably just going to submit it with it.
Okay. So you can get that done timely today? Because if it doesn't get returned to the AG's office, she'll just submit it in the way she sends it to you.
Okay.
Okay. So we're going to stop the recording and let these people in who are waiting. And they're going to have you go back to your breakout rooms where you guys can wait for this. And then you'll be able to print, sir. You'll be able to review it, ma'am. And you'll go from there. So thank you all again. And I will let them help.
This case turns on a pattern we see again and again in sovereign citizen courtroom strategy, confusing jurisdiction arguments with procedure reality. The defendant tried to frame the entire hearing around identity language, living man, special appearance, consent. But child support enforcement doesn't hinge on personal belief. It hinges on documented orders, payment records, and statutory authority. Once the judge confirmed that valid service was on file and prior orders existed, the legal battlefield narrowed fast. Here's the key consequence. Every time he objected on theory instead of numbers, he let the financial evidence go unchallenged. When asked directly whether the payment records were wrong, he had no dispute that silence is costly. In arrears hearings, uncontested numbers become enforceable judgments. The judge even adjusted the calculation method to avoid compounding interest unfairly, a move that actually reduced long-term burden. That's a court trying to keep enforcement clean and defensible on appeal. But the bigger takeaway is procedural momentum. Hearings don't stall just because someone declares they're not consenting. Once jurisdiction is established on record, the case shifts from debate to accounting, and accounting always wins when the paper trail is intact. What started as an attempt to challenge authority ended as a structured payment order with scheduled step-ups, a long-term obligation now backed by court enforcement tools. In court, refusing to engage with the math doesn't stop the math from becoming a judgment. And that's where belief systems quietly collide with legal systems.